Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Today we've got a chat about some property owners and a builder that they engage, and things don't quite go according to plan. Essentially, the plan is we're going to design a duplex home and things are going to go nice and smoothly. And the plan is to take place pursuant to a contract, and sadly, things do not go as hoped. And our property owners purport to terminate the contract. And the reasons they have for terminating are that they say the date for completion, the time by which the works were meant to be done, has passed. They say that the builder did not get a construction certificate at all, the certificate that gets issued that you need for certification. They didn't do that at all. And the third thing they say is that all these defects in the building, all these problems, they need to be rectified, and they weren't. And so the owner said, we're going to terminate right now. And what the builder said was, no. Look at the contract. The contract says that in order for you to terminate in a reasonable way and in accordance with the contract, what you have to do is you have to give 10 days notice. And so there was this argument that went on. And in the district court, at first instance, which is to say the first time the matter came before the court, the builder lost. And that first instance judge said, that 10-day obligation that you're referring to, that only relates to difficulties, breaches of the contract that can be fixed within that 10-day period. That's what the 10-day period's for. If the defects can't be remedied, can't be fixed, then the owners were entitled to terminate straight away, which is what they did. Now we're talking about the appeal decision, the next step, as it were, and in essence the builder attempted to press that argument, to repeat it, to say what the first instance judge said was wrong, and indeed the property owners had no entitlement to terminate due to that 10-day problem. The real short version of that is the Court of Appeal agreed with the first instance judge, and so the initial decision was affirmed. Now, in working through that appeal decision, a couple of interesting things stand out. One of them was the fact that the first instance judge turned attention towards the order of a demolition, or the making of a demolition order, I should say, in relation to the works. And what that meant was that any attempt to get a construction certificate, any attempt to remedy the defects would have certainly failed. And so the reason that the owners did not have to give that 10-day notice period was because the defects that were in place, the lapsing of that time for completion, remember we're after the date it was meant to be done, the absence of a construction certificate, which as our demolition order shows would never have been granted anyway, and the repairing of these defects that were found to be irreparable, leading to the demolition order, none of that could have happened anyway. So a 10-day notice period to rectify defects, rectify problems, well, it wouldn't have been possible in any case. And so for those reasons, the owners were found to be right to have terminated with immediate effect rather than on 10 days notice. And as a little side note, the owner's entitlement to damages because of this money they paid that they now want to be repaid as a result of all these breaches of the contract, the entitlement to that money wasn't reliant on valid termination, so they were still entitled to get that money back. So I hope with that quick chat, quick adventure towards an unsuccessful duplex development had for you today was a little bit of value, and I look forward to chatting with you again soon to have another coffee. And while we do that, why don't we grab another case note too? Cheers.